Hi guys! Happy Friday. It's good to see everybody. Hope everyone is doing well. We are going to be looking at, and I hope Jim can join us. I've been bad at communicating with him, and I've been stuck on a tight schedule with work. I haven't heard back from him quite yet, but he does have a link, so I'm really hoping he can join this stream. He's also going to be going live on his own channel, so whether you're on replay crew for this, check the description for that. Or if we see and hear from him here, we'll figure out what time he actually plans to go live and we'll redirect the stream over there. Also pinned in the chat right now is a link to Nick Starrow's Friday night stream that's starting at 5 p.m. So right around the corner, it's 2 hours from now. Jim usually starts like 6-ish. So catch Nick, catch Jim, catch all the one-syllable names tonight, get the whole mix going. And you guys already know what we're here for. We're here for Mounk Tounk. We're here for Antonio Sledge. This is going to be, so Jim, Tiffany Adams, they file an appeal yesterday? Day before? We looked at the state's opposition to their brief. And today we're going to look at the reply. And then we'll see where this goes from here. Right? Are they just going to kick it back down to the trial court? Is there going to be an oral hearing? Who knows? But we're going to see how Jim and Tiffany respond to what the state said and what we looked at the other day. A quick update. I saw Brooklyn was asking what's going on with the jury in the Robert Brooks trial. They recently, a few minutes ago, like 20 minutes ago, asked another question in regards to Kingsley, one of the 3 defendants, about the definition of use of force. So Still deliberating. They've asked several questions today. They asked several questions yesterday. They already took their lunch. And this is a New York court, so I would imagine if it's approaching 5 o'clock, they're going to be done for the day. I don't imagine they'll stay late. But we'll keep looking over there. If we see a verdict and there's a stream, we'll segue real quick to watch that as well. If you didn't know, when we say Robert Brooks, that's the New York State Department of Corrections and Community Supervision trial where 3 corrections officers are standing trial, accused of murder, manslaughter, gang assault on inmate Robert Brooks, who was killed after being pummeled on the table. So we will keep an eye on that. Hey to everybody that's in here. We had Lexi hopping in. Always good to see Lexi. We had Candace in here. You guys have the weird names going on. Telltale Sign. See, your name's different. Ashley Linnell, your name's the same, just with extra numbers going on there. Good to see everybody. Got Big Dog Fluff. Hope you and the family are doing well. Corky Marie. Big Buck Reed. I almost said Ruck. Geez, Louise, good to see you. I wish we could hang out more this morning. I had to do some stupid Zoom meeting for work. But good to see you again this afternoon. We've got Factual Eye, also known as O'Bailey's 71 in the building. Jasmine, Michelle. Thank you guys so much for tuning in. Red Bunny always comes around when there's a Mounk Tounk stream. Always a pleasure. Trakeisha's here for the Friday gang. We've got EJF in the building. Good to see you. Good to see you. GV. 420 is the first to drop a free Mounk Tounk. And GV the first, I think, with the Mounk Tounk emoji. So there we go. There we go. Ash also saying hello, hello. Was it Tuesday that we did the state's reply reading? Holy moly. Holy moly. Hey to Shay. Hey to Darren. We've got Bama Girl in the building. Shout out to Bama Girl and all of our Bama folks here. Oh no. Okay, so your name's different because you lost your other account. I hate when that stuff like that happens. Hopefully on the bright side, maybe it's a nice refresher. Maybe you get to like have a fresh, clean slate and reteach your YouTube algorithm if we look at the bright side. Barbie Doug, good to see you. We got Rona in the building. So naturally, I almost said Sona. So naturally. Fatima, yes, and you've got the same name, and I would know the picture too. Always good to see you. JC from the D, I think you've got the same name too. Shanikia, good to see you. I think I almost ran into you. I think I came in really late, right as Miss Sylvia was ending a stream. Miss Sylvia has just started streaming court testimony footage with Jackie Johnson. So the district attorney, you know, she had her trial. Her attorneys are Brian Steele and Keith Adams. That ended up, the judge granted their motion in relation to a flawed indictment, an issue with the indictment. But this week, Sylvia's been going over that, and I think that's where I saw you, but the chat closed. Like, I got there, and it was like, bye. So good to see you, good to see you. Yeah, YouTube's just been doing weird things with the names, guys. I don't know. We've got Woodbury Kim in the building as well. All right, you guys, so we are going to... Wait! Yay! Hey, dudes! Hey, Jim! Jim, there's a link in your X inbox. So feel free to pop in whenever. Whenever. As Shakira would say, wherever, whenever. And, why is this so squishy on the screen? Oh, there we go. I'm going to put myself up here in the corner. And Jim says my briefs don't lie. I love it. Please remake that. Does anyone know a good like AI app that lets you use likeness like to make a parody of an existing song? Kasuno doesn't allow that, right? They don't want to do copyright infringement. But I would love a quick AI parody of My Briefs Don't Lie to Shakira, but it's Jim. So, let's get into this, you guys. This was filed, I think, late last week? I don't even know. But we're going to get into it. All right, so we've got, first up, we have appellant's reply to certain of the appellee's brief's statement of facts. A, the state's description of the re-indictment's fundamental flaw is incomplete. So we just looked, a few days ago, we looked at how they said, no big deal, there were 2 indictments, but the second indictment said the correct thing. Well, let's see the counter here. The state's brief asserts, quote, while the body of the indictment changed the substance of the allegations, the caption of count 30 still alleged possession of a firearm by a convicted felon, OCGA 16-11-131. And just, guys, so caption refers to, like, remember when we looked at that huge YSL indictment? It would say all the counts, and then it would break them down further. The counts where they're kind of outlined standalone at the top, that's the caption area. The little paragraphs that are further detail about each of the counts below, that's the substance. So they're arguing here, the state was arguing, well, the caption was still correct. Well, Jim and Tiffany say this is not entirely accurate. The issue with the re-indictment is that the substance of count 30, the elements alleged, which I think we all know now why it's important to correctly allege the proper elements in an indictment. The elements alleged remained substantially unchanged, while the offense charged did change. Specifically, and let's get this footnote before we keep going. The re-indictment did remove one predicate conviction that had been included in the indictment. This revision did not materially impact the substance of count 30. While the offense charge did change, specifically, the offense charge changed from possession of a firearm by a convicted felon, 131, in the indictment, to possession of a firearm by a convicted felon, previously convicted of felony involving the use or possession of a firearm in violation of Georgia law, and this is the 133 in the re-indictment. More simply, the re-indictment changed the offense purportedly charged by count 30 without making the necessary corresponding change to the elements alleged. So, to me, I feel like Fulton County has had to deal with Brian Steele. And I'm sure he's not the only attorney doing it, but he's like making a name for himself for attacking flaws in the indictment, demurrer issues, and strategically holding out on when to do it, because he would argue, and has argued to the Georgia Supreme Court, it would be ineffective assistance of counsel to point it out early and give the state a chance to fix it. So, you would think that Fulton County would be on high alert and want to get it right whenever they're dealing with potential issues with the way indictments are written. and any changes they make and any resulting arguments they have to make about the elements of whatever count in any indictment. Doesn't seem like they're learning. B, let's go to the next one. It says the state's reproduction of the purported, quote, special conditions of probation is incomplete and misleading. This is really kind, I think, of Jim to write. Good on Tiffany. But still, this is a big deal. This is a big deal. Remember the state was saying, oh, the special conditions of probation? It's just an overly technical reading that the appellant's doing. Let's see what Jim and Tiffany say. The state's brief states as follows. So this is from the state from a few days ago. The special conditions of probation, including the acknowledgement that the state would agree to null pros count 30 after appellant completed the conditions, were listed in red print as follows. A, you shall abide in full by each and all the terms of this negotiated agreement. Your failure to abide by any term of this agreement shall constitute a violation of the agreement, ... And then they note here, Jim and Tiffany note that the appellee brief's reproduction of conditions B through I is omitted for length. So obviously this went further in the state's motion. We're cutting it down here. The issue arises from the state's claim that the language, quote, as follows, includes, quote, the acknowledgement that the state would agree to null pros count 30 after appellant completed the conditions. That material is not, in fact, included in the state's quotation. Perhaps more importantly, that's crazy. Perhaps more importantly, the section header for section 4, which explicitly designates the conditions in question as special conditions of sentence rather than special conditions of probation, is also excluded. For ease of reference, a complete reproduction of the relevant portion of the final disposition follows, with the underlined portions reflecting the material omitted from the appellee's brief. So now we're going to look at the way it's actually written. The way it's actually written. Special conditions of probation. The defendant is advised that violation of any special condition of probation may subject the defendant to a revocation of probation, and the court may require the defendant to serve up to the balance of the sentence in confinement. The defendant shall comply with all special conditions of probation as follows. And again, just a quick refresher, remember that there's general conditions and there's special conditions. And general conditions has a cap, right? If there's a petition for a revocation based on a violation of a general condition and the court agrees, it's capped, I think, 2 years maximum, or the remaining balance of what would be your time in confinement, whichever is lesser. A special condition violation can get you in trouble, and you could be serving the remaining balance. Huge difference, and it's why it's so critically important for someone to properly be on notice. So, we're going to get into those. Let's bring Jim on. You ready, Jim? Oh, I can't hear you. So there we go.
Right.
If you said no, I would have just put you up here and trusted you.
That's fair.
Guys, say hi to Jim. And then tell us, when are you going live?
I think I'll go live tomorrow, actually.
Okay, let me change my thing.
Yeah, sorry. I think I told you today. But yeah, tomorrow, I think tomorrow's the 1 year anniversary.
Alrighty. So tomorrow, guys, Jim stream, make sure you hit the bell. And that will be updated. Also, while we're pausing, Jim, I don't know if you've been looking at anything going on with the New York State Department of Corrections, that trial. But I did see...
I've been following you a little bit.
And it's been hard to follow because they only streamed the openings and closings, which were still really great to watch, guys. Totally recommend it. But another jury question, you guys. Thanks, Aaron. Jury would like to rewatch all body camera footage of Brooks in the infirmary, as well as the legal elements of murder and manslaughter again. And I don't know, guys, I followed a few New York trials. Their jury instructions are just a hot mess. And usually they don't have paperwork back there with them to explain it. And we just watched a trial with McBurney. McBurney let the instructions go back with the jury. So I don't know if we can read that much into them continuously asking for a reading of the definitions, because they probably don't have the papers with them in this New York court. So
Oh man,
go ahead.
Sorry, I was gonna say it's a Friday afternoon, and that's already gotten me in trouble once this year or so.
What has?
You remember that case, right? The one with the judge didn't want to let the jury look at the evidence a second time because it was a Friday afternoon. She didn't want to get stuck there. That was in Brunswick, Georgia.
I hate that. I hate that. Another thing I liked about McBurney's court is, hey, everyone cool with the laptop, the evidence, all the exhibits, put them back with the jury.
Yep.
You guys have any issues, let me know. It just makes more sense.
Yeah, for sure.
So, also a big thank you to Miss Kim's for staying green, becoming a member. I know this is not the first time you've been a member, but YouTube's saying that. But big thank you. And then holy moly, we've got Tate Biz in the building with a gigantic super sticker that I'm going to go have to see what it is. Because StreamYard just says super sticker. But this is incredible. Thank you so much, Tay-Biz. Always good to see you. And Keisha says she's happy you're not streaming today because she's going to go out tonight. So thanks, Jim. Thanks, Jim.
Yeah, of course.
Well, we are you're doing this correction here. Let's read through the actual way that it's written as opposed to what we just saw up here, the way the state presented it. So special conditions of probation. We read this part, we got to here, and then we went to 3 negotiated sentence. We don't have a 1, we don't have a 2.
No.
And then we have B. We have 3 and B, count 30. So this is specifically applied to count 30. Until the completion. Does the chat remember what 2 words are missing here? Let's do a little exercise, chat. See if you remember what 2 words are missing here. Count 30, until the completion of the initial trial of this case. That's not even a complete sentence. After the initial trial of this case, provided you have complied with the special conditions outlined in sections B, C, D, F, and I of section 3, special conditions of sentence of this plea agreement, the state agrees that defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. Please tell me you remember.
I remember.
The 2 words, chat. I know you know. I know you
somebody
know.
asked why we're a little small in the corner. Somebody wanted to know.
Oh, we are kind of small. You know what? I don't think I've ever set a layout for this mode to have 2 people. Does this make the document too small, or is it okay, guys? I mean, the text is actually really big on screen this time. Sometimes it ends up being really small, but if this is good, you guys, we'll keep it as is. If it's too small, we'll make us little again. Then we get to 4, special conditions of sentence. Special conditions of sentence, A. Wait, don't they only say... Where's the A here?
I don't know.
I didn't realize they messed that part up too.
Oh, no, I think that's right. Well, I mean, right's kind of a loose word, but originally it was just... Okay, I can't even describe this. It's going to take too long. But there should be, that's okay. It's okay that there's no A up there. Okay. Except that they didn't include it at all.
It's more like they just went right to a B and didn't have a section A, right? Like if you're reading the whole paper, it would just be like B, C, D rather than starting at A.
Yeah. It is confusing for sure. And they didn't include the header too, which is kind of a big deal.
Yeah, because they're directing you to follow what's under this header in this section.
Yeah.
And then this header comes in as special conditions of sentence. A, you shall abide in full by each and all of the terms of this negotiated agreement. Your failure to abide by any term of this agreement shall constitute a violation of the agreement. All right, and I think no one's got the 2 words, guys. Are you going to say it in the next few paragraphs?
Probably.
Yeah, all
I
right.
realized just
So
a second ago that I'm just repeating the things that I'm about to say in like the next paragraph, so I don't need to actually say anything.
you see the future for no
Yeah.
reason whatsoever. In the aggregate, these omissions give the misimpression, great word choice. It's not too doesn't sound like an aspersion. It sounds kind of polite. Give the misimpression that the conditions explicitly designated in the final disposition as special conditions of sentence were instead designated as special conditions of probation. While the state is entitled to argue, and does, that the special conditions of sentence are somehow also special conditions of probation, it cannot change and reform the inartful language. Is that a funny reference? Language of the final disposition in support of that proposition. Whew.
It's a good word.
Yeah.
Good word.
Yeah, it's very well used here. See, we've got the state continues to assert continues to assert incorrectly that Mr. Sledge has been convicted of attempted aggravated sexual battery. Like, this is so frustrating. The fact that this it just shows they plopped something on some other guy who, if he had read your motion and comprehended it on his own accord without knowing what actually happened at the revocation hearing, he still could have had a moment to say, oh, they're saying this, is that correct? Let me look. And he chose not to do that. He just rolled with it. He just got into the same barrel that the state gave him and just rolled through with this motion in replying.
Yeah, I mean,
this is crazy.
It's not even that relevant either. It doesn't really matter. They could have just omitted it entirely, and it wouldn't have made a difference.
Right, they didn't have to argue about it in the reply at all. Mm-hmm. Simply referring to count 30 of the reindictment proves that it was not. And then nor could it... Wait, did I read this part? In its brief, the state claimed that attempted aggravated sexual battery was the underlying charge to count 30. Simply referring to count 30 of the reindictment proves that it was not. Nor could it have been, because 15 SC 138994 did not include a conviction for attempted aggravated sexual battery, and Antonio Sledge has never been charged with, let alone convicted of, attempted aggravated sexual battery. It bears noting that the witness at the revocation hearing did not make any statement that would support the claim that attempted aggravated sexual battery served as a predicate conviction to count 30. Now, what was Jolly? Was her name Jolly? So you guys remember when Judge Whitaker was communicating with the probation officer. Her last name's Jolly. And she was going through the criminal history to help the court decide on what to do at the probation revocation hearing. And she's the one that actually read out the attempted aggravated sexual battery. But it was Adam Abadi that was sitting there at the bench at the state's table. Love wasn't there at the table, but we saw her with her leather jacket walking around in the room. He's the one that said, that was the predicate conviction for the count 30. So right here, it looks like Jim and Tiffany are hey, we're not trying to take aim at the probation officer.
No.
But we're just setting the record straight.
Yeah, actually, nobody said that. Abade said something else that was also inaccurate. But,
a different predicate act, but they used... But then this guy in the... What's the guy?
He was talking... So, okay. So we have to go back to a different error. This is a misrepresentation about a It's literally 3 layers of a misrepresentation. Okay. So the first thing they said was that the 2015 case had a conviction for 131. But it didn't. And so then they said that... Abade said that there was a cocaine-related conviction that was the predicate act to that 131. But both of those things don't exist because you can't have a predicate for something that doesn't exist. So now we're 2 layers of misrepresentation. And then now they're saying that... Actually, it's really 4 now that I think about it. They're saying
it's
that...
nested.
It's nested misrepresentation. So now they're saying that the non-existent... sexual battery was the non-existent predicate to the non-existent, well, not really non-existent 131. I guess it's 5 layers actually, because they're changing the 131 from the non-existent.
The longer you talk, the more layers.
I guess it's 5. I guess it's 5. It's 5. Yeah, it's a Russian nesting doll. Lennon nesting doll.
We're gonna pause you before you make it 6. Furthermore, while the record does not contain a certified copy of the final disposition entered in 15 SC 138994, it does include a copy of the state's December 9th, 2022 state's notice in aggravation and intent to seek recidivist punishment and notice of intent to impeach defendant with prior convictions, which sets forth...
Excuse me.
Huh?
Wait, oh no.
Did you make a mistake?
No, the six, oh man. It said convictins originally. It must have gotten autospell corrected.
It said convictins?
Yeah, I really like that.
You and your convictins. Which sets forth the crimes. That's so funny because I wonder if they're going to stop and look for what's wrong with it and then not see it. Which sets forth the crimes of convictins under that indictment. Conspicuously absent, oh boy, is any mention of attempted aggravated sexual battery or similar offense. The state also discusses the alleged events underlying indictment 15 SC 138994 in overt acts 41 through 46 of count 1. This is all the drive-by stuff, right? The April Adele Drive.
Yeah.
Okay, guys. You guys remember that, right? You know, shooting at the ops over. I always forget her name.
Denise Bell.
She took the stand. Huh?
Denise Bell?
Well, Denise Bell, but who was the paramour?
Oh my god. I can't remember.
The only word I can think of is paramour now. So, and you guys, the chat says it every time. I don't remember her name because I only remember paramour. Chat will remember.
Yeah, I know you're talking about. I can't think of it.
Those factual allegations make clear that the incident underlying this indictment did not relate to any crimes of that nature. The state's continued insistence that Mr. Sledge has been convicted of this heinous crime when he clearly and easily, verifiably has not, is both puzzling and troubling. Yeah, I'm glad you guys got to, like... I feel like you wanted to address this very badly.
Yeah.
I mean, you weren't going to make an issue of it in any of these filings, but then they just kept going with it.
Yeah. Yeah, they kind of walked into that one. Because like I said, it's not really that relevant. Or at all relevant, really. But they keep bringing it up. They're making it relevant by continuing to mention it, which is just strange.
My opinion is they want to influence the judge to use a revocation, or if she has to resentence, to consider this an opportunity to punish the person she's revoking the probation for an unrelated wrongdoing that shouldn't even be attributed to the person in question here. Yeah. So I think it's to poke and prod. Don't just give a nice little resentence. D, we've got the next argument. The state's treatment of the original written plea agreement is inconsistent. Well, so my read on it is in the state's opposition to your appeal brief. I don't know if they really conceptualized that there were two different written versions. Like they should have, because obviously you can't do it this way. But it's almost like it's possible the guy that wrote that opposition just looked at it as like a verbal okey doke.
Yeah, I mean,
which doesn't make sense.
Yeah, there's one verbal, one oral, but I mean, I'm not sure they completely thought it through all the way to the end. That's what I'll say about that.
Well, you'll also say that Mr. Sledge and the state entered into a written plea agreement on December 28th, 2022. That written plea agreement is referred to herein as the original/written plea agreement. At Mr. Sledge's guilty plea hearing, also on December 28th, 2022, the parties renegotiated certain terms and entered into a new oral plea agreement, referred to herein as the final oral plea agreement. And this is the way you broke this down when you guys first filed the appeal brief. You designated the difference. You used the same labels for version 1 versus version 2, original versus final. So anybody that wasn't maybe rushing to file an opposition because maybe they were busy writing other motions for reconsideration about civil forfeiture matters, maybe they would have pieced it together.
Yeah, it seems like they kind of got it at some points, but not the consequences of the distinction, which I'll mention.
Fatima, we mentioned Adrian Love. Fatima said, "Mouth almighty, tongue everlasting." Love's forever nickname. Very, very fitting. Following the parties' entry into the final/oral plea agreement, the original/written plea agreement was no longer an effective operative agreement. The original, because guys, you can't just have two contemporaneously existing plea agreements. It just doesn't make sense. The original written plea agreement was not adopted by the trial court. It was the final/oral plea agreement that was ultimately adopted by the trial court. The state appellee's brief, and I don't remember, did the state include further portions of the transcript from the plea hearing after the parties were going to confer?
Does what include?
I think the state's opposition brief, they only included like transcripts from the plea colloquy up to the part where Love asked for permission to confer and then come back, but they didn't continue including what happened after that.
I think they referenced it.
Maybe? Okay.
But yeah, I mean, definitely at the trial level, they didn't mention any of that stuff. If you go back and watch like the...
That's linked in the description.
Yeah, when you go back Oh, sorry.
I have it, guys. If you want to go back and watch when Adrian Love read the plea colloquy or played the video during the YSL trial of the December 2022 plea colloquy for Antonio Sledge, that clip is linked in the description of this video if you've missed that. So definitely worth watching if you haven't seen how Love presented all of this during the trial.
Yeah. Yeah, I meant like the also, I think I sent it to you. I think Court TV has the second half of the hearing, but they didn't show. They cut it off right at the end of the first half. They didn't actually show the most important part.
Well, the interesting part about that is during the YSL trial, the state opposed Brian Steele trying to rely on a YouTube link to recall, like, hey, go back and look at the stream. But here, when they want to make the arguments, they submitted YouTube footage.
Yep.
And clearly they were relying on YouTube footage in relation to this specific matter. They could have also gone and found that full clip. Or noticed that the clip they found, maybe they only found the one that cut out. And, oh, it's incomplete, so maybe we'll rely on the transcript here. But I think the only reason I've seen the transcript pieces is because you included it as an exhibit, not just in your appeal brief, but also in your motion, maybe for reconsideration.
Yeah.
So, YouTube is great sometimes when we want to use it.
Yeah.
We've got the state's appellee's brief, which acknowledges that the original/written plea agreement was not the party's operative plea agreement. And then you quote here from their brief, quote, the parties came up with a new plea agreement. Implicitly admits that a substantial portion of the material factual representation made to the trial court in connection with its petition to revoke Mr. Sledge's probation were false. Oops. The state's petition to revoke attaches, incorporates, and repeatedly refers to the original/written plea agreement as the plea agreement, despite the fact that it clearly was not, as the state now acknowledges, the operative plea agreement. And then, right, they did the AS1 exhibit, right? They relied on AS1 as the exhibit.
Yeah.
Your footnote, we got oh, is this clickable? Yeah. We can jump to the footnotes. The guilty plea hearing and the probation revocation matter were held before different judges.
Yeah, that was just to note that the judge wouldn't know, have their own independent knowledge of the fact that there were different plea agreements.
And probably difficult to take judicial notice of such matters. For example, the petition to revoke states that Mr. Sledge, quote, confirmed both in writing and verbally that he entered into the plea agreement freely, knowingly, and voluntarily without any force, threat, or coercion. In support of that contention, the state cited to the original/written plea agreement, which again was null and void at all relevant times. The only written confirmation related to the original/written plea agreement. Oh. Okay. Yeah. Am I reading this weird? The only written confirmation related to the original/written plea agreement, there absolutely was not any written confirmation with respect to the operative final/oral plea agreement. Well.
Yeah, the I mean, the language is kind of funny to begin with because it's like, I swear that nobody had a gun to my head when I signed this. Like, what does that really do for anybody.
Yeah, I don't know, because it's like if somebody's in a dire situation, one would expect that they might be scared to ask for help,
Yeah.
if they felt like they were under pressure.
Yeah.
So,
Yeah, no,
uh,
it is word a little confusing. Basically, it just means that they were relying on the written agreement. Like, look at all these things he signed when the final version was an oral agreement,
yep.
and you can't sign that. So that just kind of gets to that issue.
Yeah, and again, it could go either way. Like they're not paying attention and keeping like a pecking order of what was happening when and what document falls within what like actual action happening in the court. Or it's just we don't care about the order. We just have something on paper. So we're gonna shove this paper in your face and tell you to accept this, even if we're not presenting it to you with the full context. So I'm inclined to think the latter, but For example, the state argued the following with emphasis added. An exhibit within that plea transcript is the plea agreement, which includes the sections, I believe it's section 4 and section 5 of the plea agreement, as it relates to the factual acknowledgments that the defendant swore under oath during the plea, that he had reviewed, then initialed each one of the factual acknowledgments, and then signed that he, again, understood and reviewed each one of the acknowledgments that he initialed as a part of the special conditions of his plea. Then when called to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true. Essentially, the entirety of this argument is misleading at best, and entirely false at its worst. And a quick pause here, but without any documentation, wouldn't we need somebody to be a witness to testify that this is... If we don't have the extra document, if it got lost somewhere, wouldn't we need to call a witness and say, well, there was another copy and he did sign it?
Yeah, I mean, there really wasn't a written. It was never reduced to writing, so it's just kind of. I mean, that's kind of the funny thing, right? Is that Sledge testified that he was told that he could just orally told that he could, clarify things on the stand.
So
And
we're relying on an oral acceptance of what's no longer an operative plea agreement, and that's supposed to be okay. But the court, in my opinion, I don't think the court gave any leniency towards Antonio Sledge, saying that that's what Love told him orally, that he could give context on the stand.
yeah,
Because she punished him for it. She found it akin to perjury. So
yeah, I mean, that's the thing is like him saying that there was I think at one point during the revocation hearing, the question was asked, was there anything put in writing that you could change your testimony or clarify your testimony or whatever? But nothing was put in writing because the entire final agreement was oral. So there's no evidence that that wasn't the agreement. I mean, that's kind of the issue.
And Mounk Tounk was the only one in the room that got it.
He was. It was like once you see it, once you understand it, it's really obvious when you look at like the plea agreement and the sentence that you're not looking at the right one. But it's like one of those light bulb moments. If you don't spot it, you won't spot it. But if you know, I mean, he knew that he had a sentence on count 30. So I think it was pretty clear to him that it wasn't when they handed him the plea agreement to like asked him, is this your plea agreement? That he knew that it wasn't because it's obviously not.
We gotta go and read. Are you gonna play any clips tomorrow? I think you should. For the anniversary.
I'm still not sure what to do, but I kind of want to go back to like the really old stuff, like the 2003, 2004 stuff. But we'll see.
Well, you do remember that some of the stuff that the state wrote about in their opposition brief here, they put 2004 instead of 2024, which I can't even fault somebody for that. I can totally see why somebody would make that mistake.
Yeah.
Essentially, the entirety of this argument is misleading at best and entirely false at worst. Yep, not very good. The, quote, exhibit within that plea transcript, end quote, was not, quote, the plea agreement. It was the original/written plea agreement, which was null and void. The final oral plea agreement was the plea agreement. What Mr. Sledge initialed and signed was, naturally, the original written plea agreement. He did not, of course, sign or initial the final oral plea agreement, as it was never reduced to writing. In sum, following the trial court's rejection of the original written plea agreement, the state secured Mr. Sledge's guilty plea and resultant probated sentence by negotiating and entering into the final oral plea agreement. It then turned around and secured the revocation of that probated sentence by simply ignoring the existence of the final oral plea agreement and representing to the trial court that the original written plea agreement was the operative agreement. There you go. And it sucks that you have to spell this out, not just for the
Again.
court you're arguing to, but I feel like you have to spell this out for the state. Because if this guy that wrote this opposition doesn't fully understand what he was dropped into.
Yeah, for sure. I mean, it is complicated. It's not, it is.
It's a lot.
It's an extensive factual background for sure. I don't blame anybody for not getting it, right away.
No, it's confusing. And then the more time that goes on and the more I read something, it like re-blurs. Like I'll understand something at one point and then a few weeks will go by and looking at it again, it's like, wait, you've got to reparse it. Mr. Sledge's probation was revoked for alleged misrepresentations to the trial court. Oh, okay, that's fiery. Woo. We got a little fire on screen for you. I like that.
That one was fun. That one felt good.
That was good. 2. All right, so next section, guys, we've got Mr. Sledge's plea agreement was plainly a package deal. Reading all of this, I forget about all of the other mess. And this is a huge mess, too. I still cannot get over that we're arguing that the word can't is not a no. Like, please tell me I can't have a cookie. Please tell me I can't take my lunch break 15 minutes early.
Yeah.
And then try to tell me that it was my choice, not you saying no.
Yeah, I think there's actually kind of an interesting example of why they have the bright line rule. Because it can get messy as to whether something's a rejection or not. But that's why they have the rule that says you have to tell, you just have to tell them if you're rejecting. Because you can always get into these nuances of what is or isn't a rejection.
Well, and what's beautiful here that you have to respell all of these arguments out, right? Like, I think if they understood some of the things that you were saying, their argument would have been a bit more concise and focused. And then your reply wouldn't have to rehash all of this stuff. But now with this, what's happening here is we just went through this whole section about how they're ignoring the original written plea agreement. And then we're teeing up into this. And when you take both of these things happening in conjunction, it just makes it seem like more important that the judge in this moment needed to spell it out that this was a separate agreement.
Yeah, it is tricky that there are just multiple different errors that kind of overlap. So now here we're talking about the plea agreements was the package deal, but I have to refer to the written plea agreement because that's the one that was used below. So it just gets complicated because it's just layers and layers of questionable facts.
Got a lot of people popping in. we put the flames on the screen and everybody's coming in. It's like YouTube must have a trigger like, oh, that stream must be spicy. There's some animated fire. Let's tell everyone to show up. Happy Friday again, everyone joining now. We are looking at the Mounk Tounk mess. I shouldn't word it that way because it makes it sound like it's his mess. He's got to deal with it, unfortunately.
Yeah.
This is a Fulton County mess. But yeah, let's do this package deal thing, you guys. This is just a pet peeve of semantics for me, let alone the implications it's having. But we've got A, the interplay between the substance of the re-indictment and the substance of Mr. Sledge's plea agreement require that the plea agreement be treated as a package deal. Is this going to feel like deja vu?
Yeah, probably.
Okay. All right, let me get the fire off the screen. As argued in the appellant's brief, as we already argued, as we already spelled out, Mr. Sledge's entry into the plea agreement was predicated upon the resolution of both counts 1 and 30. This approach was necessitated by the fact that the allegations underlying count 30 are the same allegation underlying count 1's alleged overt act, 151, in furtherance of the alleged RICO conspiracy. Given that a guilty plea to a given count constitutes an admission to the material allegations contained in that count, Mr. Sledge's guilty plea to count 1 necessarily includes... You should have like put this in all caps, bolded it, and underlined it. Because I think that makes it easy for Fulton County to like get your point. Because that's what they do when they want to make a point.
They really emphasize, I think, too much.
They use all of it. They do the bold, the italics, the underlying, and the capital letters.
Yeah, Love does that a lot. She does a lot of like bold, caps, underlined.
She tries to bring her voice into the paper, on paper. So it necessarily includes an admission to the material allegations of count 30. Were Mr. Sledge to proceed to trial on count 30, the state could simply introduce into evidence the guilty plea to count 1, which is effectively an admission of guilt as to count 30. This is a good point. I don't remember you guys, you might have, but I don't remember you guys spelling this angle of argument out previously.
Yeah, it's kind of an addition. It's not really an addition, but it's just another way of saying it. But I don't think I framed it that way previously. But
the written, and I mean,
it's definitely true.
The appeals court, they'll see both arguments in the brief and this reply. The written plea agreement addresses this exact issue. We've got a footnote. It says, while Mr. Sledge maintains that the written plea agreement is entirely void, there has been no ruling to that effect. As a result, it is effectively impossible to disambiguate two errors. One, the revocation of probation on the basis of the novated and void written plea agreement, and two, the treatment of the final oral plea agreement as if it were not a package deal. While appellant's brief and this reply brief endeavor to clearly and consistently delineate these two issues, it's not always feasible. Well, yes. And that's why it would have been nice if we just had a clearer record during the plea hearing that, you know, we rejected the first one. This is the next one. This is here. It is on paper.
Yeah. We're
going to re-sign. Do you agree to these new ones? Everything, check all the boxes. Where were we? Where's this footnote? Okay. The written plea agreement addresses exact issue by 1, resolving both counts 1 and 30, and 2, including a term calling for Mr. Sledge to waive his Fifth Amendment rights. In other words, Mr. Sledge agreed to waive his Fifth Amendment rights in connection with both count 1. This is such a good argument. Why the heck didn't you raise this right away? To me, this is so critical. Whenever I read briefs, right, and then wait to see what an appeals court does with it, it's like they'll ignore everything, but if you give them, if there's an issue that deals with, like, somebody's constitutional rights, like their Fifth Amendment right being trampled on, all of a sudden I feel like we're writing this opinion because we want to address this thing.
Yeah, that could be.
So, just my take. Because that is crazy if he only wanted... But yeah, he would agree to waive his Fifth Amendment rights in connection with both counts 1 and 30 because the parties had reached a negotiated sentence that would necessitate the reservation of Fifth Amendment rights. The appellee's brief correctly acknowledged that this court has looked at plea agreements as package deals when the defects affect the whole deal. For the foregoing reasons, that is exactly the case here. We've got B. The state has repeatedly referred to Mr. Sledge's sentence as a single 30-year term of sentence, not as two separate sentences. Furthermore, the state has clearly... Is this surprising? This might not even be misleading. This might just be because they just never get it right. Furthermore, the state has clearly and repeatedly treated Mr. Sledge's plea agreement as a package deal, imposing a single collective sentence. Several examples of this follow. And I think... So, Tommy's in the chat. You were, when Tommy, I think, was watching the replay for the state's opposition, I think Tommy caught this. Tommy was like, where is this 30 years coming from? And it's inherent confusion. It's baked into the state's interpretation, incorrect interpretation.
Yeah, 35 is the wrong one. So okay, so 35 is the max for both RICO and 131. That's where they got 35. 30 was the right one because the RICO on count 1 was 15 years. And then the sentence, this is so stupid. This is, again, like another layers of errors thing because it involves like the 133 thing. So 35 is what you get if you add 133 and RICO together. So that's where they got 35.
But
And
then they
then-
went with 131-ish.
Yeah, it's like I can't even describe it. And then 30 years would be if you had RICO and I guess 131, or maybe if you have 15 years for RICO and 133 could also be 30 years. So now I'm not sure. But
And
they're-
also the difference of the lower floor, right? Where the difference between
Yeah.
concurrent versus consecutive, the
Yeah.
floor would be lower.
Yeah, I mean, if it was
properly with
yeah, if it was correct, the max would be 25. That's the right number. But or 20, depending on how you look at it, either 20 or 25.
I mean, I hate sentencing math. Like when they're reading and when someone's being sentenced and we're watching those, I try to follow it and I never want to say out loud on stream what I calculated it to be. I'm always like, I think it's this. I don't know though. So, let's see.
Yeah.
The original written plea
Review.
agreement. This is where we have the 35. Defendant understands fully that defendant's violation of any provision or of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall nullify any promise made by the district attorney to null pros count 30 of this indictment and may result in defendant being sentenced to serve as much as 35 years of confinement. Because with an understanding, with the expectation that it was 133, that would be consecutive, not concurrent sentencing. And remember, this is the original written plea agreement. That's what we're relying on to say that Mounk Tounk initialed. He signed it. It's on paper. This is the one that is now void because they changed it. But when he initialed and when he signed, he was under the impression that if he went to trial, this would be what he was facing if convicted.
Yeah.
But he had a chance to get way less than that by agreeing to this original and now void plea. So, and that was the main argument that you used in the motion to vacate. When you did the motion to vacate, Judge Whitaker didn't address the package deal argument in her order, like granting it a resentencing for the 5 years.
Right,
and you
right.
also leaned on this a lot more in your initial appeal brief.
Yeah, just in general, this reply brief, like I couldn't respond to everything just because of the word count. So I kind of had to pick and choose. So there's more stuff that I would have liked to have said, but
You've got to put your motion through like a chat GPT and say, using brevity, write this like a caveman to see how much words could shorten down. And it's word count, not letter count, right?
Yep.
Okay. So just go for the big words. Say more.
Yeah. I do use ChatGPT for proofreading. That's the only thing I trust it for, but it can be useful for that. It messes that up most of the time too, but sometimes it finds stuff that's helpful.
Write this brief as, and then just come up with random celebrity voices. So we went over the original written plea. We've got the revocation petition. So in the revocation petition, remember this was Adam Abadi. On December 28th, 2022, the defendant pleaded guilty to conspiracy to violate the Racketeer Influence and Corrupt Organizations Act and possession of a firearm by a convicted felon. I gotta give him props for getting the conspiracy part, though. They did actually include the right caption there for the RICO. And possession of a firearm by a convicted felon.
Yeah, so the interesting thing about this is that this kind of hides the fact that it was an illegal sentence. I don't think it was intentional. Like he intentionally hit it or anything, but 30 years for those two convictions could be legal because it's a 20-year max and a 10-year max. So by saying that it's a 30-year sentence, you're kind of covering it. If you said that it was 15 and 15, it would obviously be an illegal. He would be revealing that it's an illegal sentence. But by saying it's a 30-year sentence for both, it sounds like it's a legal sentence, basically. If that makes sense.
Well, and it's also an instance of them treating it as a package. If they're going to necessarily treat it like one sentence, then how can you argue that the plea agreement isn't a package deal if you're treating the sentence like one?
Yeah, for sure.
It's just contradictory. No matter which way they try to argue, the lid pops off the other side, and now there's another issue. It's like whack-a-mole. So, and then we've got the revocation hearing. Oh, wait, I missed this part. That Chief Judge Glanville subsequently sentenced him to the 30 years, as Jim was just discussing. The revocation hearing. Mr. Sledge just started on December 8th of 2023. I think he got credit for the time. I think he was in for 2 years. So he would have 26 and change or 25 and change years remaining. So that would again go with it's the 30, right? Because if it has to be 25 plus something.
Yep.
And then 3, we've got the appellant's brief argued that the trial court illegally increased Mr. Sledge's sentence on count 1, not count 30. So the state correctly argues that the trial court did not increase appellant's sentence on count 30, asserting that, quote, the trial court did not improperly increase appellant's sentence on count 30. Given that the sentence, they literally said this, that's how that reads. Given that the sentence imposed on count 30 was legally speaking, the first sentence imposed on count 30, as the initial sentence was void and a nullity, it could not possibly have been increased. This is where the, quote, resentencing misnomer can confuse matters. The resentencing of an illegal sentence is, technically speaking, the first sentence imposed, not a resentence. While resentencing is generally a useful shorthand in these situations, it can, as here, muddy the procedural waters. Oh, I like that phrase. Muddy the procedural waters. Sounds like a weird, like, A&E show. Fortunately for the appellant, he did not argue that his sentence on count 30 was increased. Oh gosh, this is great. I can hear this in your voice. I can hear this in your voice.
Yeah,
well,
actually kind of...
Well, sure, but fortunately... Were you going to say something?
Yeah, the thing about resentencing, that was kind of like a pet peeve of mine that was in the case law. They keep referring to like it makes sense to like call it resentencing, but it really is the first sentence. And sometimes it, like I said, it can be a useful shorthand to say resentencing, but really it is just like the first sentence. And there are a few cases where that confusion like messes things up, like here, I guess.
Yeah, and I'd say here because you have the different actions from love to a body, and now this new guy that has to deal with all of it.
Yep.
If he's inheriting something and looks at resentencing and doesn't understand the order of events, yep, he would go with the obvious interpretation of what resentencing would encompass.
Yeah.
So, also shout out to Zach in the chat. I see Zach saying she made me walk the plank. I think this is a great time to mention we've been watching the New York State Department of Corrections trial over here. Luis, always following different dockets, looking at what's going on. Amazing, amazing person. Over on Dolly Talk's channel, we just had a verdict come back for, it was a guy charged with a prison fight. The inmate gets in fights with the corrections officers.
Okay.
And jury comes back and they say not guilty on the top 2 counts. I think they hung on the lower 2 counts.
Yeah.
So really cool situation if you're looking at the Robert Brooks trial to hear that an inmate was put on trial for, attacking corrections officers, and the jury seems to, at least for the major counts, agree that he was justified or that the state didn't meet their burden of proving that he committed the top level acts against the corrections officers. So I only caught a little bit of that and I have to catch up and rewatch it. But now seeing Zach come in here talking about walking the plank, which is you can gamble with coins over in Dolly Talks chat and take the chat on a group pirate adventure. So that's what he's referring to. Made me think of that whole thing, and I meant to tell the chat that I think they would like that case. So here is Dolly's link here. And yeah, and Louis says that trial would make your jaw drop. So especially if you guys wanted to watch the Robert Brooks trial, which isn't being streamed, the testimony wasn't streamed, go check that out. I think it was like only 3 days or so, right? It was shorter. So, but thank you again, Zach, for reminding me of that, and for the super here saying, I'm definitely not Zach. The supers come through with your display name. They don't do the @ name like this would. You're the Prince of Wales with the @ name, but you're Zach for the super chat. So don't send any more super chats. Keep your disguise. But thank you so much. I'm definitely not Zach, and you should definitely not time me out. Well, okay, maybe just 60 seconds. Have at it, mods. Give him the 60 seconds. So there we go. There we go. And And it's Trenton watched it too, said they had good body cam on that trial, so I'm surprised it split. So there you go, guys. Tons of stuff to watch. And is there any recent updates before we get back to reading? All right, the last update I see is from 53 minutes ago that we pulled up. I think Aaron posted it in the chat that the jury wants to rewatch body camera footage of Brooks in the infirmary, as well as the legal elements of murder and manslaughter. Oh, and then he notes that the video footage is 30 minutes long, and this is about 53 minutes ago. So that's a lot. So there's that. No other updates for the Robert Brooks stuff. And then we were here at Muddying the Procedural Waters. So fortunately for the appellant, for Mounk Tounk, he did not argue that his sentence on count 30 was increased. He argued that his sentence on count 1 was increased. And again, this is just so golden because they're trying to lump the sentence together as one. And now you're having to parse the two apart. You're having to make it look like less of the package that the state is making the sentence. Ironically.
Yeah, kind of.
So he argued that his sentence on count 1 was increased. The pertinent section heading of the appellant's brief reads, quote, "The trial court erred by improperly increasing the appellant's sentence on count 1 in violation of the double jeopardy clause of the Fifth Amendment. Given the apparent ambiguity, a clarifying calculation follows. As the number of days spent by Mr. Sledge in pretrial incarceration cannot be calculated from the documents provided in the record, it will be assumed that Mr. Sledge was incarcerated from the date of the indictment through December 28th, 2022, the date on which he was sentenced to probation." We had a footnote here that says, "Credit for the period of pretrial incarceration is not an issue and immaterial to the legal question. This assumption is made for the sake of simplicity and completeness." This period totals 234 days. In sum, Mr. Sledge has served the following. So we've got the 234 days of pretrial incarceration. You know, if you guys wanted to get the context on why someone might want to take a plea, we have 660 days of probation starting from December 29th, 2022 through the date of his revocation, October 18th, 2024. So again, that's tomorrow. 1 year makes tomorrow of the probation revocation. And then 365 days of incarceration following revocation from October 19th through October 18th, 2025. So did you jump this based on when you were going to file?
Yeah, I just use that as a round number. That's what the footnote says, is that I just
okay. This reply brief was filed on October 14th. October 18th, 2025 was used for simplicity. I could have just clicked the footnote. Look at that. This totals 1,259 days. Under this calculation, Mr. Sledge would complete his 15-year sentence on count 1. Oh, there you go. So you're subtly pointing out the 15-year.
Yeah, 15 years is okay on count 1.
So, but I mean, we just heard the state it's just a group 30-year sentence altogether. It's just all one thing.
Sure. Yep.
Would complete his 15-year sentence on count 1 on May 8th, 2037. Geez. The issue here relates to the period of time that Mr. Sledge served on probation, 660 days. The trial court's amended final disposition, dated April 28th, 2025, effectively extends Mr. Sledge's sentence on count 1 by removing those 660 days from the calculation by restarting the 15-year sentence effective October 18th, 2025. It does this by stating that the, quote, first 5 years of Mr. Sledge's probation were revoked on October 18th, 2025. Thus, under the amended final disposition, the first 5 of the 15-year probated sentence on count 1 commenced on October 18th, 2025. Accordingly, Mr. Sledge's time served is as follows. And I thought this is something I don't keep in memory, but I remember when we read, I think the motion for reconsideration, you argued this as well. I got what you were saying, and then when I read the state's brief opposition, I felt so lost in the way they were arguing against this. Like, it made me question myself. So
yeah, I think they were trying to argue that. So originally, it was supposed to just amend count 30. The court's, the amended sentence,
the revocation.
Yeah, it was just supposed to amend count 30, but it kind of didn't. like it accidentally amended count one. Like I'm sure that the court didn't intend to do this, but
It's
it
still
did.
an issue.
Yeah.
So
Yeah, they were basically just saying that the court limited the amended sentence to count 30. But
well, and
if you look,
this seems so difficult because I feel like with this particular issue, if you were able to just like casually, everybody gets together and says, "Hey, there's a little bit of an issue here. Whitaker, the state, are you all on the same page?" I think Whitaker would be like, "Oops, yeah." But you have to go through all these motions. You have to go to the appeals, and if that doesn't work, either they remand you back down to the trial court, or it's denied wholly, and then you file a different type of motion than with the trial court. And it just seems like such a waste of time.
yeah, I mean, the thing is like it's talking like it is kind of inconsistent the amended disposition, but it's talking about a period of 20 years, not a period of 5 years. If it was only talking about count 30, then it would only say 5 years opposed to 20 years. So it's just confusing, but it's confusing in a bad way.
Yeah, a bad way that has serious implications,
Yeah.
not just for understanding, but for someone's time in custody. They say, thus, under the amended final disposition, the first 5 of the 15-year probated sentence on count 1 commenced on October 18th, 2025. Accordingly, Mr. Sledge's time served is as follows. So you've got the 234 days of pretrial incarceration from May 9th, the original indictment date, through December 28th, 2022, and then 365 days of incarceration following revocation. So that's the revocation hearing, the day after the revocation hearing, through like tomorrow to round it out for the 1 year.
Yeah.
This totals $599. Put simply, the trial court restarted the 15-year period of probation, less the same 234 days credited for time served in pretrial incarceration on October 18th, 2024. Mr. Sledge cannot receive credit for time served as to the 660 days because the sentence no longer reflects his service of that time. The amended final disposition effectively wrote that time off, and Mr. Sledge must reserve those same 660 days, which increases the term of his sentence on count 1 by that same period. Finally, the state citation to Anderson v. State, while correct, is irrelevant because the issue here does not relate to credit for time served in custody, but for time served on probation. Of course, credit must be given for time served on probation. The court, this is quoting Stallings v. Spark. It's a 2012 case. The court cannot disregard the time a defendant has served on probation when calculating the time remaining on the defendant's sentence after probation has been revoked. Yeah, I think they were just confusing me on their argument in this part of their
Yeah, it's a confusing
opposition.
issue for sure. Don't
So
get me wrong.
I'm still kind of like, the way I look at it is like everybody needs to be at the table and looking at the numbers and get it right and double check the work and then get it right for the sake of getting it right, and don't just let it be wrong because we're not willing to double check.
Yeah.
Right? That just seems like the basic thing to do from all sides.
Yeah. Well, it seems like they kind of conceded on the hearing, the sentencing hearing issue. So it seems like there
Of
will be a
course, because
hearing.
it's not their fault.
Yeah.
So, and I don't know if you get to that in the brief, but that was, I thought that was funny. I thought that was humorous when I was looking at the opposition.
Yeah.
Tay Biz says, I don't know if you want to take a stab at this too. Tay Biz, thank you so much again for the super sponsoring the stream. I think I kicked my banner off. Hold on, wait, we've got to get the Prince of Wales in the sponsorship banner too. So Tay Biz TV and the Prince of Wales.
Let's
for
see. Has there
sponsoring the
been
stream.
any proof or evidence of this factual statements being manipulated? I don't think so. I think it was more an issue of just multiple versions going back and forth. I will say that they started engaging in negotiations that, like, after the close of business the night before the plea hearing, which kind of suggests to me that they weren't really sufficiently concerned with an accurate set of factual acknowledgments, because if they had been, they would have started before the night before.
Well, I was say, my opinion is there, especially like seeing this spelled out a bit more, is there's just an absence of something that could get you there. I mean, how would you prove that there was a change when we still only have the original written plea agreement? and we don't have a new written version to compare it to.
Yeah. Yeah, I mean, it's one of the many versions that wasn't adopted. It's no different than any of the other
just in the
versions that were adopted.
ethers, multiple ethers, just multiple versions just floating around.
Actually, there is one thing that I should mention. So you might remember from the revocation hearing where Judge Whitaker said, what were exact words? She was mentioning that when Miss Love went through with the factual acknowledgments one by one, that didn't raise a bell. That didn't ring a bell that the factual acknowledgments had been changed or something like that. That didn't actually happen. That was the Sledge and Sumlin. Well, Sumlin didn't have like public factual acknowledgments. We don't know if they were. But of the other 7 that had guilty pleas in December of 22, he was the only one where they didn't read through the factual acknowledgments during the hearing to confirm that they were true. So like Winnie Lee, Greer, Gunna, Hick. I don't know. I don't need to go through all of them. But every other one.
For Winnie Lee was almost a year ago too. Wasn't that like October 24th?
Which one?
Winnie Lee on the stand?
Yeah. Just about. He was.
We're like a week away from that.
Freakway.
Yeah, maybe. All right, we've got to do reunion streams for the revocation and the mess that's transpired since. I think you should do a Winnie Lee one. I think you should do a rewatch of the Winnie Lee.
Yeah, for sure. But
you were only chat side. You didn't even have a YouTube channel then.
No. I was just yelling on YouTube comments.
You could pull those up as memories in a week whenever the anniversary is, because Halloween was the plea deal day for Young Thug, right?
Yeah.
Was it?
Yeah.
So, yeah, that was wow. A lot happened last October, like just like steamrolling through all of this, and it still drives me crazy that Judge Whitaker revokes Mounk Tounk's probation, and then like a few court days later, she loses it on the state for just being such a hot mess. And I always wonder if the revocation would have went differently if she had different views of, or was willing to accept at that point that the state was messy, the state was unorganized. So it's just really unfortunate that played out in the order it played out in. And who knows? Sure. Who knows if we got to that? Would the state have even had time to file a petition to revoke Mounk Tounk's probation if they had to deal with the Winnie Lee stuff that week? Like it's just a butterfly effect.
Yeah, for sure.
So I also see shout out to Dizzy. I didn't see you. I see you came in during the stream. It's good to see you. Thanks for hanging out with us. And Tay Biz said that a few days ago we mentioned that Tay Biz had an interview. And we're like, go watch it. And now YouTube's playing games. So that really sucks, Tay Biz. And then I saw you say you're about to go live. So I have your YouTube link here. In a second, I'm going to grab your X link. Guys, go make sure you follow Tay Biz. Fight back against the YouTube, whatever they're doing. But he's going to re-upload that interview over on X. So let me get that for you. And that, again, guys, if you are already following or want to start following everything going on with Mickey Steins over in Letcher County, Kentucky, the sheriff that shoots the judge, there's a whole lot of hot mess going on over there.
Yeah, that's what I've been hearing.
It just, every time there's a new development, it's just like it went from like playing poker strip clubs in garages with parolees and like court officers, like just a whole bunch of stuff going on. A lot of mess that I think it's great that it's getting attention. And Tay Biz has been one of the very early ones giving like a deep dive spotlight on the issues over there. So here is the X link for Tay Biz.
I gotta say, I have a thing at 1:30. I have to jump off at 1:30.
Alrighty. And you said you're gonna go live tomorrow, but you don't know when.
I can pick a time. Let's say 5 o'clock. What's a good time? Did anyone in chat have a requested time?
Chat, vote on a time. Put the time zone in your vote. Put the time zone in your vote. So that way we can, because if everyone's saying just numbers and no time zone, that's kind of not going to work.
It'll probably be like 5 or 6 Eastern. That's what I usually go for.
All right. So it'll be like a happy hour stream with Jim. Happy hour with Happily Angry Lawyer. That's what you should call it.
Oh, I'm going to write that down. I'm gonna add that to my notes.
There you go. There you go. And there are plenty of venues that do happy hour for like 3 hours, right? So you can do happy
Yeah,
hour for 3 time zones. So
yeah, for sure. Yeah, that's my old bars used to do 3 hours.
yeah, there we go. We have 3 to 5 Eastern, 5 Eastern. EJF says daytime plans, so later Eastern's good.
Okay,
There we
cool.
go. There we go.
Is that a Maine Coon? What is that? It's a big cat.
Adorable. I don't know, like, species or breeds of anything. So, so
It
there we
is.
go.
There we go.
Hey, special bendy bros. And thank you, Trikisha just dropped Hal's link. So make sure you follow for Happy Hour with Hal. Happy Hour. And when you have to jump, just,
Yeah, for sure.
just yell something, throw something. We've got argument 4 here that Mr. Sledge entered a guilty plea on count 30, but it was not knowing and voluntary. The state is correct that Mr. Sledge argued in his motion to vacate that he entered a guilty plea to count 30. Oh, this is this part where they said that your pleading in 2025 is proof that he agreed in 2022. Which charge 16-11-131. The state's brief goes astray when it asserts that this argument constitutes a judicial admission that the plea was entered knowingly and voluntarily. This assertion is incorrect for at least 2 reasons. At least! First, the arguments in question do not constitute judicial admissions because they are legal conclusions drawn by undersigned counsel following an analysis of the following facts. The fact that you even need to say this is ridiculous.
Yeah, I agree on that one. Actually, I think it's a frivolous argument.
Again, I hope it's the thing that makes the Court of Appeals like, we would have just remanded, but we also want to address something because this is stupid. Mr. Sledge entered a guilty plea. These are the analysis of the following facts. That Mr. Sledge entered a guilty plea to count 30. That count 30 of the reindictment charges the elements of a violation of 16-11-131. And that count 30 of the reindictment does not charge the elements of 16-11-133. And it's interesting because in the state's opposition, they acknowledge that there is a difference, right? So they're supporting what you're relying on for your analysis here, and why Mr. Sledge, if wouldn't necessarily have been knowingly agreeing to something if it was inherently confusing and incorrect. So given these facts, undersigned counsel concluded, and the trial court agreed, that there is no question that when Mr. Sledge entered a guilty plea to count 30, he was in fact entering a guilty plea to violating 16-11-131. And remember, guys, in the state's opposition, they kept, like 3 times, I think they said, the allegedly void sentence.
I watched that part of your stream. Some of it was too frustrating for me to watch, so I had to go back off and on. But yeah, it was like you said, it was like a blogger who's trying not to get sued, so they keep sprinkling the alleged in there.
Yeah, and they're the ones making up the tea. Like you allegedly does not work when you're the one making the allegation. When you're the source of the rumor or the allegation, allegedly does not work. Allegedly just means you're reporting on what another source has alleged.
Yeah, it's like it already was resolved too. Like
by a judge, a fact finder. What a slap to the trial court judge.
Yeah, it's probably forced. I'll give him a pass on that one. It's probably just force of habit, but it was kind of funny. And frustrating. But
you're so nice. You're so nice.
I get it.
This is an obvious. Wait, did I read this whole thing? Yes. Okay. Right? Yeah, he was in fact, that there is no question that when Mr. Sledge entered a guilty plea to count 30, he was in fact entering a guilty plea to 131. This is an obvious legal conclusion that would be drawn by any attorney reviewing the elements of the reindictment. Hey, this is a great way to subtly make an ineffective assistance of the other counsel argument. The most relevant portion of the motion to vacate is reproduced below. Per the state's own motion.
I had to make it less petty. The original version was more petty.
On your deathbed, can you release a book of your slander folders and put it in your will? Please, guys, get your estate plans going, have a will, do the things. Jim, please put something in your directives that instructs somebody to release your slander folders and your previous versions.
I mean, once I'm done with this stuff, I'll definitely be more open with with my thoughts on everything.
We're going to get together in 20 years, you guys. We're going to do it. Per the state's own motion in limine on the substance of the indictment, the substance, not the caption, of the indictment controls. Love it. Love it. Quote the state. See Exhibit D. Following this logic, it is even more apparent that Mr. Sledge entered a plea to OCGA 16-1. We're just going to say 131 and not 133. The allegations alleged in count 30 in the re-indictment fail to allege the required elements of 133 and would not survive a journal demur. If Mr. Sledge were to admit to all the allegations in count 30 as if they were 133, he would not be guilty of a crime. Count 30 fails to allege the crime committed while using the firearm, among other elements. Therefore, Mr. Sledge entered his plea to 131B as listed in his final disposition. Furthermore, the appellee's brief acknowledges that legal conclusions do not constitute admissions in judicio. How do you pronounce that?
I don't know. I think
You're just making me feel better. Is it like
idea.
a soft, like a judicio? Is it judicio? Judicio? In judicio? Judicio?
I mean, I think Latin would be like a hard C, but they probably say judicio. I still don't even know how to say. What's the one I don't know how to say?
Judicio sounds crazy.
Yeah, I guess they don't have J's in Latin either. So maybe not. Who did I cut out?
Oh,
Oh,
no.
no. Okay.
I hear you. I heard you. Let's see.
What's the other one I don't know how to say? Oh, rule nisi, rule nisi, rule nisi. I have no idea.
Oh, I also say null pros because, like, potentially criminal says in Ohio, they just call it nollies. Like, they carry out the E with the Y sound. I just say null pros. It's nice and I don't do the nolli proseque. I'm not going to say the whole thing.
There is like a general trend towards like less Latin phrases and less legalese, but I don't know any of those. I've never seen any of those phrases before Georgia.
All right, Max, we're going with in judicio. Another one that why am I losing what it's called? Oh, giglio. Giglio, giglio. Like, when I have to say that there's Brady and Giglio violations, half the time I'll say Giglio, half the time I'll say Giglio.
I just think of the Ben Affleck movie.
Yes! It's ruined me.
Man.
It set me up for pronunciation failure. Oh, my goodness. I hope they never get rid of sua sponte. That one's so fun to say. It sounds like a little spell. Sua sponte.
Yeah.
Sua sponte.
Well, in California, they just say judicial admissions. So, you know, if you want to say judicial admission, that works for me.
Oh, okay. Okay. Oh, it's way shorter that way. It does not constitute judicial admissions. Yeah. So if that would read, furthermore, the appellee's brief acknowledges that such legal conclusions do not constitute judicial admissions by providing the following quote from oh God, now we have names. Wanshoff v. Erdman, or maybe it's Vanshoff. A judicial admission applies only to the admission of fact and does not apply where the admission is merely the opinion or conclusion of the pleader as to fact or law. Guys, we went on a whole rabbit hole about pronunciations and a simpler way to say things, but this seems like common sense, right? And there's case law spelling it out. It's case law from 1998 that I doubt has been challenged, where a judicial admission only applies to an admission of fact and not an opinion or argument of the person writing the pleading, right? That's why they're called arguments, arguendo. So,
yeah, I mean, it was my analysis that, like, it wasn't his analysis. So you can't use the fact that, like, I fixed one thing to stop me from fixing
wouldn't
another
that
thing.
necessarily mean that he didn't admit it also previously then, if we're going to do that? So I don't know. Yeah. Oh, and yes, factual lie also puts in a +1 for Ipsy Dixit. Which I
really tried to work that one in, but it was too forced. I had to take it out.
I think Ipsy Dixit is understood by like judges. Yeah. I think if you argue it, they'll be like, it's a Ipsy Dixit argument. Yeah. Also, shout out to Katie, and also earlier, you guys, and Treva Smith. I don't know why I always forget her
SIMTH.
name. Love ruined it by calling her the paramour. Like,
Okay,
whole
I'm gonna jump
mess.
off now.
Alrighty, you guys. Thank
But
you, Jim, for your
yeah, of course.
time and your, doing all of this too, not just jumping on the stream.
Yeah, of course.
Thank you so much, and see you tomorrow.
Yeah, I'll talk to you soon.
Woohoo!
Thanks, everybody.
And as we kick Jim out of here, we've got Nick in the chat. We've got Nick in the chat here. It should still be pinned at the top of the chat, you guys. There is a link for Nick Staro's stream, which is now going to be starting in 30 minutes. We'll redirect over there. I think this will time up nicely with that because we've got 6 pages, including the signature pages. But Nick's going to be covering several different things tonight. One of the things, it's going to be such a blind thing for me to look at. Karen Reed it's so hard for me to keep up with anything around Karen Reed lately because it's just, there's so much side story in fighting. It's not even fighting between free Karen Reed and anti-free Karen Reed anymore. It's like, I don't even know what's going on. So it's been hard to catch happenings that relate to it. But I saw that one of the things Nick is covering today is going to be an interview. It's going to be a Celebrate interview with, I think, everybody's favorite expert witness in the Karen Reed trial. Well, maybe not the favorite. It's kind of a hard fight. I had no idea that was even a thing. So I'm so excited to go into that blind and see what you have to say about it. If you guys have never been to one of Nick's Friday streams, we were talking about Hal doing a happy hour show. Every Friday, Nick does something of the same theme. Let me get the direct link. In case you don't make it to our redirect at the end of the stream, here is a direct link. And it's always a happy hour Friday show over on Nick Staro's. So he's going to be doing the Celebrate. He's calling it the idiot interview. Oh man, and you're also going to be covering that the WWE bans wrestler from wrestling. So that's interesting. That's also going to be new to me. What's not new to me, he's going to be talking about a news station, KSAT, KSAT 12, who's copywriting trial streams. Now, channels have the right to use their own footage, but and any intellectual property that they might do around trial footage, but trial footage itself is public information, and they're being tools about it. So he's going to talk a little bit about that as well. So that's going to be a good one. If you can't make today's show, I know he's also recently been covering the hyperbolic chamber explosion case. Just crazy stuff to think about. So check him out for that as well. Let's see. Sorry, I just saw this. I love good wordplay. Stimson says, Wiffle's interview was a big whiff. I love it. I love it. And big thank you again, Nick Star out here with the 5 gifted subs, making 5 people green. Big appreciation here. We're going to have to go drop some green gifts over on your channel. So be there if you want to get a gift. It's going to be great. And Betsy says that stream requires cursey words. It's going to be a good time. It's going to be a good time. It's going to be a good time. We've got to the end of this here. We have no Jim to explain things that I don't understand, but we'll make it through. We will make it through, chat. We've got finally in this section. So we're still talking about the state in their opposition brief using the pleading, the appeal brief, the arguments made in the appeal brief by Jim and Tiffany, counsel for Antonio Sledge, as a factual admission on behalf of Mounk Tounk, and some type of peek into the 2022 state of mind of Mounk Tounk during the plea hearing, which was ridiculous when we read it, but that's what we're talking about in case you didn't see that. So they say that finally in this section, the state argues, if appellant did not intelligently or knowingly enter his plea, appellant should have filed a motion to withdraw a guilty plea on that basis. However, appellant chose to file a motion to vacate count 30, stating he pleaded guilty to 131B and should have been sentenced according to that charge. This argument's flawed. A motion to withdraw a guilty plea must be filed in the term of court in which the defendant is sentenced. Otherwise, the trial court lacks jurisdiction to entertain such a motion. And we got a citation here to Teague v. State. That's 2025. So remember, we saw the state in their opposition say, oh, they're looking at something outdated. Well, and then they're quoting Campus v. State from 2023. Mr. Sledge was sentenced on December 28th, 2022. Per OCGA 15-16-3, Fulton County Superior Court's terms commence on the first Monday in January, March, May, July, September, and November. Thus, the trial court lacked jurisdiction to entertain such a motion as of January 2nd, 2023, the first day of the subsequent term of court. Thus, Mr. Sledge could not have moved to withdraw his guilty plea in early 2025 when his motion to vacate was filed. For purposes of context, it bears mention that this is why appellant's brief noted that the provision of Mr. Sledge's sentence, purportedly allowing him to withdraw his guilty plea if certain conditions were met, was reduced to mere illusory consideration in the final oral plea agreement. So way to round this out. So we're going back. We've got all these issues layered in, nested in. Well, we have all of this coming together, and it's a bigger issue than maybe just a simple mistake, because now you have the state arguing, well, he should have withdrawn through the trial court, where the court wouldn't have had jurisdiction for it. But additionally, we have this issue that the state seems to dance over the provision that would allow him to withdraw his guilty plea if certain conditions were met. Now, I asked towards the beginning of the stream if you guys remember the two words. If you guys remember the two important words that were missing from the final disposition versus what would have been the disposition. And it was an incomplete sentence. We're going to go back up to where it says until. One of the issues is that originally, this section read count 30, sentencing withheld until the completion of the initial trial of this case. The final disposition that's actually submitted after the oral plea agreement does not have those two words. It just reads count 30 until the completion of the initial trial of this case. So if we go back down here, we're rounding out with why all of the layers together are a big issue. So again, he says, for purposes of context, it bears mention that this is why appellant's brief noted that the provision of Mr. Sledge's sentence, purportedly allowing to him withdraw his guilty plea if certain conditions were met. That certain condition being, including sentencing withheld until the conclusion of the trial in this case, the YSL trial. Sentencing withheld. That language is no longer there. Was reduced to mere illusory consideration in the final oral plea agreement. Because the original written plea agreement provided for sentencing to be withheld on count 30 until after Mr. Sledge testified, the trial court would have retained jurisdiction to permit Mr. Sledge to withdraw his guilty plea had it sentenced accordingly. However, pursuant to the final oral plea agreement, the final disposition did impose a sentence on count 30 on December 28th, 2022, and therefore the trial court lost jurisdiction to permit guilty plea withdrawal on January 2nd, 2023. Accordingly, this is italicized, the state would never have been able to hold up its end of the plea agreement. Now again, it's a counter argument to a specific argument that the state made, but when you zoom out the big picture issue here, there's another big picture issue here that we have this written agreement and then we have a final oral agreement. And the state is making references in these recent replies. They're referencing the original written agreement that is null and void, that has language that is missing from the final disposition. And yet they're arguing something that would be true if we did in fact have this valid original agreement before it was changed. Before it was changed because the court said you can't do it this way. And again, this is so complicated. So it really should not go unnoticed that Jim and Tiffany have taken the time to parse this out, to digest it, and then be able to lay it out in motions why it's so problematic. Because they're giving us the easy stuff. They're taking this volume of everything that's happened from the indictment through today, and they're saying, these are the dates. This is the paperwork. This is where everything fits, and this is why it's a problem. It's just such great advocacy, great research, great presentation, really. Presentation's important. Because this is really hard to understand. The state doesn't seem to understand it. And if they do, as soon as someone might understand it, it seems like they kick it to somebody else to write the next brief, next reply. So we've got next argument here. This court's review of the legality of the sentence imposed pursuant to the revocation of Mr. Sledge's probation is proper, given that OCGA 5-6-34D, which provides for this court's review of orders that may affect the proceedings below. So as explained in section 3 above, Mr. Sledge contends that his sentence on count 1 was illegally increased by way of the trial court's entry of its amended final disposition. Should this court agree, it will be confronted with the challenge of shaping the appropriate relief. Were this court to simply order the sentence on count 1 reinstated, it would be giving effect to the illegal portion of the sentence on count 1, the 5-year term of incarceration. Accordingly, 5-6-34D provides for jurisdiction. This court's review of the revocation sentence is appropriate. So we want this court to hear it. Don't kick it back down. We've got 6. Mr. Sledge's ineffective assistance of counsel claims are properly and necessarily before this court. The state is correct that Mr. Sledge did not raise his ineffective assistance claims before the trial court. However, as detailed in Caskey v. State from 2024, very recent, that is not the end of the analysis. To preserve the issue of ineffective assistance of previous counsel, new counsel must raise the issue at the earliest practicable opportunity of post-conviction review. There you go. So we have a link to it in the description here if you want to go back and see what the state said in their opposition brief. But the state ignored the context of a change of counsel and what the case law permits the procedure there for new ineffective assistance of counsel claims. And we have right here in this case law, it's Caskey v. State, which I feel like the state cited, but they didn't cite this part. Maybe I'm getting confused on the cases. Well, new counsel, checkbox, can raise the issue, must raise the issue at the earliest practicable opportunity of post-conviction review. This is the first appeal initiative. We're reading the reply to the opposition, but the initial appellate brief raised this issue. They are required. Tiffany and Jim were required, or it would have been waived if they did not raise this issue in the appellate brief they filed like a month and a half ago. So not only is it a proper venue, it is the proper time and venue to raise the issue because there was a change of counsel and this is their first opportunity for post-conviction review. Generally, when the appeal presents the earliest practicable opportunity to raise an ineffectiveness claim, and the claim is indeed raised for the first time on appeal, our appellate courts remand the case to the trial court for an evidentiary hearing on the issue. Remand is not mandated if we can determine from the record that the defendant cannot establish ineffective assistance of counsel. Here, this appeal did present the earliest practicable opportunity to raise an ineffectiveness claim. Upon their engagement, Mr. Sledge's new counsel filed the motion to vacate. Ineffective assistance claims cannot be raised via a motion to vacate, which are a relatively narrow procedural vehicle. And if they tried then, they would have been ignored. This isn't the way to do it. They say, see Von Thomas v. State, that motions to vacate a void sentence generally are limited to claims that, even assuming the existence and validity of the conviction for which the sentence was imposed, the law does not authorize the sentence. Accordingly, new counsel could not have presented the ineffective assistance claims by way of the motion to vacate, because it doesn't fit this argument here. However, as discussed in Caskey, such claims can be raised for the first time on appeal. Not only can they be raised for the first time on appeal, it can be inferred from Caskey that the failure, maybe it's Cascade, to raise such arguments for the first time on appeal would constitute a waiver. There you go. That's why the word must. Where was it? Must. There we go. That word, very, very important. Words have meanings. Accordingly, appellant raised those claims for the first time in the instant appeal. So this appeal, which follows from his new counsel's very first filing in this case. Again, had he failed to raise those claims in his appellant's brief, they would have been waived. So there we go, ending with real simple argument, straight to the point. And we've got, shout out to Miss Tiffany G. Adams. Let's not forget the G. Read the whole name. And, I didn't see, I didn't see Jim here in the signatory page. But whatever, we know he was there. We know he was in the gym. We know he was there. And Bernick. Alex Bernick is the ADA that did the opposition brief. I think he inherited a hot mess from a body. So there we go, guys. We made it through. We made it through. And what happens from here? I mean, maybe they'll go through with an oral hearing. Maybe they'll remand it back down to the court. I would really love... I think it'd still be interesting if it's remanded back down to the trial court to see what happens from there. The downside, of course, being that it just makes things take more time, right? It adds to the timetable. We'd have to start doing new vehicles and whatever. I'd still be interested in seeing how the trial court approaches this and who's there to argue for the state. But there are some things here that, and again, if you miss the state's opposition, there are just some things that the state argued in its opposition brief that Tiffany and Jim didn't even touch on. In my opinion, they probably didn't, and Jim's off this screen, but they probably didn't have to touch on it because it was such a ridiculous argument on its face. So, things like can't not meaning a rejection of something, not being a no. Just crazy. So I would love, it would satisfy me, I'd be very excited to see the appeals court be like, hey, we would have just simply remanded this back down to the trial court, but we got to talk about this one thing, at least this one thing. So we'll have to see. Of course, we'll keep following what's going on. Jim's going to be live tomorrow to talk more in depth about this and some of the other indictments that he's looked at. I'm not sure if that's going to be limited to YSL indictments, but we've heard him mention that Mounk Tounk's plea and the mess surrounding it probably wasn't the worst one of the YSL indictments. So yes, it gets worse. It gets worse. So if you like following stuff like this, make sure you are following Jim. I also want to take a moment to share the Fit Lawyer, Tiffany G. Adams. I'm going to call her the Fit Lawyer here because that's the easiest way to find her YouTube channel if you're going to search it on your own. Link is in the description and I'm dropping in the chat right now. The Fit Lawyer ATL, aka Tiffany G. Adams. Make sure you go follow. She is licensed in Georgia. This is how Jim was able to get the Pro Hoc Vice admission. They've been doing such great work in advocacy for Antonio Sledge. It's just been an incredibly motivating thing to see this happen, for us to be here. And I would love to, what Jim and Tiffany are doing, I think the more we support them and they feel good about what they're doing, not only will it be good motivation and good appreciation for them, but it might rub off on some other people. It might also show defendants who are like, there's no chance for me, there's no lawyers that care, and I don't know where to go to get assistance to fight something like this. I didn't even know you could fight things after you're convicted. I think just the general sense of raising awareness, and that if someone screws you over, if you're sentenced to something that's a legally and void sentence, maybe there's someone out there that can help you. So, yeah. Simpson says Fulton County screwed up more than one. That's not believable. Another day, another Fulton County mess. And we've also got FFS in the building. Always good to see you. FFS said, the G stands for going places. Love it, love it. And also, thanks everyone for joining us. Please hit the like. So please do that, you guys. You can hit it as many times as you like, as long as it's an odd number of times. So it'll stay highlighted as a thumbs up. I don't really know if that makes a difference. I really think throwing things on the screen like this make YouTube feel like something's a good stream. So there's that. Mookie's also in the building. We got Mookie in the chat. It makes your name lowercase when it gives you this @ symbol. I don't like that. I like when your name's all caps. YouTube's got to get it together. Always good to see you. Hope you are doing well. Steph is in the building as well. It's been a lot of reunion moments here whenever we get together for Mounk Tounk. Guys, we are going to be going over to Nick Starro. Although, Tay-Biz, are you doing... Tay-Biz, are you also going to be doing a live? Or... Oh, wait, hold on. Do we have an update in the New York State Department of Corrections? Let's do that before we get into our redirect. Judge is sending them home 1 minute ago. So update number 6. This is from Sean Mills, you guys. He's a reporter with the Rome Sentinel, like a local publication from Rome, New York. And they're being sent home until 10 a.m. Monday. So I think if you use Facebook, this is where he's doing the text-based reporting. There's also a link to follow Sean with Rome Sentinel if you want to get those text-based updates throughout the day on Monday. But again, no verdict again for the New York State Department of Corrections. So, whew. Okay, and then Tay-Biz says, I just got back in town, so I'm not doing a live today. We'll be live tomorrow, though. Okay, so we've got Tay-Biz tomorrow. We've got HappilyAngryLawyer. You guys might need to coordinate, like, because Tay-Biz has, like, a smooth, booming audio setup. Like, it's just he's so easy to listen to. Hal's easy to listen to, but he gets fired up, right? You got to do, like a nighttime to follow after the happy hour. You guys could, like, get, like, a club night content stream thing going. I think that would be great. So keep an eye out for that, you guys. This, again, is going to take us over to Nick Starro. Any closing recommendations, closing thoughts, final words in the chat? Put them in there now. We can read them before we redirect. And while you guys do that, I'm going to set up on the back end here to take us on a trip. No, not Nick Taro. All right, there we go. Redirect is set up to take us over to Nick Starro's slightly buzzed Friday Law Show. So that's going to be a good time. EJF says, if anyone's going out tomorrow, be safe. Be safe always, you guys. Always good to be safe. Max says we all have to follow this closely all the way until we get the hopefully good news. Heck yeah. Heck yeah. And when, I don't even want to say if, I hope it's a when that day comes, right? I want that reporter Chase to chase Fonnie down and get an interview. Like, oh, so we heard that YSL trial that ended with, barely any convictions on the murder counts. Now you have this other issue, right? What happened there? Chase him down, chase her down. Actually, isn't there also a Fonnie Willis hearing coming up? I have it on my calendar. Let me check what day that is. Thought I put it on. Okay. November 4th. Fonnie Willis. It's the Willis v. Cowsert case, the Georgia Special Committee. So if you guys remember watching like the Georgia Senate Special Committee hearings where, they have like the panel of the panel, and then they have the table. Amanda Timpson sat at the same table when she testified as well. Ashley Merchant sat at that table to give testimony. That case. There's a hearing, and Fonnie's supposed to show up. She says she's going to show up. That is going to be November 4th. So we will get together. We'll watch that. I put 10 a.m., but I'm not sure if that's the actual start time. But we'll see. We'll see. So that, keep your calendar marked for that if you want to pay attention to Fonnie Willis shenanigans. The following day, Wednesday the 5th, we've confirmed will be the next hearing date for Courtney Clenny. And then before that, on October 23rd, Tyrone Blackburn, attorney, has his criminal court appearance. And then Terrell Efron has his court appearance. This is in the case where Tacopina is named. So the ASAP Rocky and Joseph Tacopina defamation case filed by ASAP Really, Terrell Efron, is also going to be the 23rd. I don't know if there will be cameras there, but he does have new counsel representing him. So we'll see how that goes. Initially, it was going to be him trying to fight an anti-slap, a special motion to strike, up against Joe Tacopina. So we'll see how that plays out now that he has counsel again. And that wraps it up. That wraps it up, you guys. Everybody have a safe weekend. Very safe weekend. Be safe. Tay-Biz is going to schedule around 2 p.m. Eastern tomorrow, right? And then I think Jim said 5 p.m. Eastern, so we've got a double feature tomorrow. That's going to be a great time. And then Mookie lost his streak. Uh-oh. And then I'm going to drop the link to Nick one more time in case you don't get redirected, and then we'll get over there. All right, so there is Nick's link in the chat. This should take us right over there. Hope to see you there, and see you also tomorrow. Bye, guys.